Has there been any research done on the legal consequences of using restorative justice and making respondents admit to the harm they caused? I remember you mentioned something about the fear of defense attorneys, and how do you address compliance with Miranda rights, etc.?
The way that we protect any statements that happen during the preparation for a restorative justice conference or the conference itself is by developing a very strong and protective confidentiality policy that is modeled on victim offender mediation programs, and the legal basis often comes from parts of criminal codes that allow for discussions of culpability during plea negotiations. So the statutory basis for these confidentiality protections has been around in most codes for a long time. What we do is we apply those to restorative justice practices. And we are in the process of proposing new legislation to actually expand that in our code in Washington, D.C., but our confidentiality policy exists so that we actually don't need statutory protection. We are just doing that to institutionalize our work. But the confidentiality policy that we have says that nothing anybody says in the preparation for a restorative justice conference, doing any of the work with the restorative justice facilitator, or during the conference or post-conference during the monitoring of the agreement, can be shared with anybody. All statements are protected in order to allow for all of the parties who are involved in restorative justice to speak freely and authentically and truthfully about what happened. Because that is so central to the restorative justice process, this confidentiality policy binds the prosecutor from ever subpoenaing anybody to speak about statements that were made, including the facilitator or anybody else, or using or eliciting any of those statements in trial. The exceptions, there are two exceptions for this confidentiality policy. One exception is for if somebody in the restorative justice setting threatens to do harm to themselves or to others. And the second exception is for Brady material. So for Brady material is exculpatory information that the government has that they have to hand over to the defense attorney because it might help prove the innocence of their client. So if the government is in possession of information that could help prove the innocence of the defendant, by law, by the Constitution, they have to hand that information over to the defense attorney so they can use it in making decisions about trial and how they're going to use it for trial. So in the rare case that a restorative justice process breaks down, no statements can be used, even if the prosecutor then gets the case and decides to go to trial. No statements from that can be elicited or used or known even to the prosecutors involved in the case. It's firewalled from them. However, if the case is going to go to trial, then we have a process by which the facilitator and the prosecutor would sit down to see if there's any exculpatory information for the respondent or defendant, and that would be handed over to the defense. That being said, we've been running our program for 6 years, and we've never had to make any exceptions to our confidentiality policy for Brady or harm of self or others or anything. These are provisions that are created for the rare circumstances that they might be needed, but we haven't come across that in the hundreds of cases that we've done.
Is there policy that protects 25 and under from having a lifelong criminal record? And do you support such a policy utilized across the board for people who undergo restorative justice practices?
There are already in Washington, D.C., and hopefully in Connecticut as well, there are already confidentiality laws that protect the criminal records or involvement or contact with the justice system of young people under 18, which is appropriate. because the things we as adults would not want to be held accountable for decisions we made under 18 and have them impact our ability to get jobs, to get student loans, to get housing, and other things that are important to our success. It makes perfect sense that those policies that protect people's criminal records from public dissemination extend beyond for juveniles to young people up to the age of 25, given what we know about brain development and the fact that, you know, we are still making poor decisions up until 25, and we shouldn't have our lives constrained by those decisions throughout, you know, a productive rest of our lives. In fact, in Germany and in Norway and in some of the other kind of Western democracies that we want to compare ourselves to, criminal records are never public for anyone. It goes so dramatically and fundamentally against the idea that a person would be able to rehabilitate, serve their time, and then be productive member of society, that when I got a chance to visit Germany and talk to criminal justice leaders there, and when we mentioned the fact that in the United States, people's criminal records are public, and long after they've served their sentence, they can be used against them for other collateral things like housing and employment and all those things, they were aghast. And they said, but then how do you expect people to become law-abiding, productive citizens if they're always going to be saddled with these criminal records? And that is a very good question. So yes, I am supportive of it. In our restorative justice program, young people who are almost all young people, even though they've been charged with serious violent crimes, who decide to do restorative justice and are successful with the restorative justice process, have their cases dismissed. And one of the, you know, goals and purposes of that is that they will then not have an adjudication history. Mm-hmm. Those histories are not supposed to be public anyway, but even if they are to the military, to law enforcement hiring, etc. And so they are impactful, even if they're not, you know, fully public. And so the fact that we protect young people from having those convictions is an important part of our work.
In Connecticut, some of the disputes are with repeat youth offenders. What would you say to those who want to process repeat youth offenders as adults?
Yeah, I would just emphasize again what I said before, and that is the process of a young person aging out of criminal behavior is just that. It's a process, and it's like addiction, and there is relapse. And the more that we condemn somebody because they do something again, the less likely that they are going to ever age out of crime or be able to be a productive citizen and therefore have a desire and motivation and hope to live a different life. But what it says to me when a young person gets convicted again and again and again of something and goes through our justice system again and again is that our justice system is not being successful at stopping them from committing crime. Mm-hmm. So, you know, do we keep doing that or do we try something else? And I believe that every child, wherever they are in their process of aging out of crime, can learn a lot from the process of building empathy and understanding the impact of their behavior through restorative justice.
What are the qualifications of your facilitators? Do they have a social work degree? What training would you suggest facilitators have before they can run groups, and is special training being utilized for sexual harm cases? If so, what do you find is the rationale behind differentiating sexual harm cases versus all others?
Yeah. So when I hire restorative justice facilitators, I think about two main things. Number one, I'm looking for somebody with very, very high emotional intelligence, because they have to do a lot of different types of relationship building very quickly. So they have to be able to build trust and comfortability very quickly with a young person who's been charged with a crime and their family members, many of whom are very suspicious of government and the prosecutors. That is one of the most important relationships they build and one of the hardest they you know, understandably one of the hardest relationships to build. They also have to be able to build trust and rapport with the victims of crime, who at this moment tend to be highly emotional, completely understandably. They have valid emotions of anger and fear and danger and suspicion. And the facilitator needs to be able to make them feel safe, understand that they're on their side, be able to listen to them and walk with them, meet them where they are, validate what they've been through, and provide them a lot of information about different options. They also have to be able to navigate effectively relationships with prosecutors and defense attorneys when they have to say to prosecutors, I am working with you and I am going to take good care of your victims, but I will not tell you anything that the young person charged has said or will say or what they're going to do. They also have to convince the defense attorneys that you are going to take very good care of their clients and their clients' families, and you can be trusted with that sacred responsibility, even though I'm also speaking to the victim of the crime and the prosecutor, and I am not going to tell you anything about what they are saying or doing. So it takes a lot of incredible relationship building skills and very kind of off the charts emotional intelligence to be a good facilitator. And that's the number one thing I'm looking for. The second, arguably equally important thing that I'm looking for is that our restorative justice facilitators reflect the communities that have experienced overcriminalization, because that is a critical component in being able to relate to and be relevant to the young people who've been charged with the crime or the adults when we work with them, because they too have experienced not only being criminalized by the system, but typically a lifetime of bias and systemic racism. And these are parts of the experience that they have gone through, and they need to be able to feel very safe with the person who they're working with in order to be vulnerable and honest about what they did, which is what we need them to be. And when you're working with teenagers, as anybody who has teenagers or has worked with teenagers, you'll know it takes a very magical and special relationship with one to allow that teenager, especially somebody who's been hurt or burned before and is facing a lot of danger, to open up and be vulnerable enough to tell you the truth and be willing to tell everyone the truth about things that they're very ashamed about. And so because these things are so difficult, our facilitators need to be very, very unique people. In order to find those people, the people with the demographic makeup and history and experience to be able to build that vulnerability relationship with a young person who's been charged, and the emotional intelligence to be able to deal with that person and their family and the victim and the prosecutor and the defense attorney, I need to make sure that the barriers to entry to that position are very low. So we have no requirements of educational background. We have no requirements of having any experience with restorative justice. We do, in fact, say that we give preference for people who come from communities that have been overcriminalized and for people who've been justice involved themselves, even though we work for a prosecutor's office, and we have changed our hiring practices within HR to make sure that we don't bounce those people because of a criminal record check. And so because those two things are so important, we have reduced the barriers around everything else, both like barriers around criminal records, but also barriers around education and access to, what is still an elite and culturally, kind of privileged position to be aware of what restorative justice is and to be versed in restorative justice language and and to understand that culture. That can't be a barrier too.
Do you find any characteristics that are in common with facilitators? Like people who are really sensitive to their clients' needs or display a lot of warmth?
That's a really good question. I think that, the nice thing about the term emotional intelligence is that it encompasses a lot of that. And I think warmth is really, really valuable. And a lot of our facilitators are very warm and friendly. But I think that alone is not enough, because with teenagers, They are so good at smelling, you know, insincerity, that if you have somebody who is just warm and loving, but can't garner their respect by also demanding accountability, then the teenagers will walk all over them. Rightly so.
Mhm.
So our facilitators come from all different backgrounds. I have facilitators who are social workers, licensed social workers, and I have a facilitator who's a licensed therapist who's getting his PhD. I've got facilitators that have worked in schools, and I've got facilitators who were paralegals, right, in government jobs, and who had no background in, you know, therapeutic work or anything like that. But what I can tell you is that our facilitators, in order to get young people and teenagers in particular to feel safe and comfortable being vulnerable, sometimes takes a lot of warmth and love. And sometimes takes somebody who can give compassion and show true care and love for a kid and also call out their bullshit.
There is so much of an absence of that authentic caring and nurturing for these kids. Would you say that these kids are just looking for love in all the wrong places? Like, I joined a gang because they love me. Or, I remember a legislator walked into a juvenile detention center and she said, "What can I do for you?" And the kid said, "Love me."
I think that kids at base need love and care and compassion. I think it's maybe in some circumstances simplistic to say that's all that kids need. Because after a lifetime of 13 or 15 years of experiencing poverty and bias and racism and exposure to violence and loss of parents to incarceration, maybe homelessness, child welfare, abuse, any of those things. Sometimes you'll get a kid who's like, "I want you to love me." But most teenagers that end up in the justice system are not the ones that's behavior can be solved with just love. Because the way that they are manifesting all of this trauma is in real problematic behaviors, which is like very, very significant anger, lashing out towards themselves and others, super self-destructive behavior. And I can tell you this because I'm a parent of teenagers. It is not even just teenagers that have gone through trauma. And I can sit there and my parents, their grandparents can sit there all day long and be like, "I love you, I love you, I love you." And they'll be like, "Can't be bothered," right? So I think that there is more to I think at base what you're saying is correct. Like the underlying base for this is a need for self-worth and self-love. And one component of that is people showing them love. But there is a lot more to it, and it's very complicated. And I think if it were just that you needed people to give them more hugs, it would be a lot easier than it is, in fact.